Hi everyone, in this video we're going to explore the law on labor strikes using the labor code and some principles that we can find in jurisprudence. Disclaimer, this video is only for educational purposes only and not a substitute for professional legal advice. Please contact a lawyer for the proper assessment of your case, and for corrections or concerns, please contact me in my Facebook account or comment down below. Thank you once again. This is Brian De Rosa of lexrex.ph. So let's go to strikes. Where can you find the provisions on strikes and lockouts? By the way, I'm gonna pause every time I ask a question so that you can also think, and I will show the answers. So where can we find the provisions? Mainly under the labor code. It's Article 278 to 292. So what is a strike? A strike is a temporary stoppage of work by the concerted action of employees as a result of a labor dispute. So we can see here the nature, that is temporary, and the means is concerted action, and then the cause is a labor dispute. This is Article 2190 of the Labor Code. It is concerted refusal by employees to do any work for their employer. So one of the prominent keywords there is concerted. So what is the state policy in relation to strike? So the state policy, the principle governing the principles that govern why there is a strike is free trade unionism, meaning workers have the basic right to form, join, or support labor organizations of their choice, to negotiate with their employers, and participate in activities for mutual benefit and protection. So this is in fact related to self-preservation, and for the state to recognize the right of workers that they can enforce or levy their interest before their employers. So this includes the freedom to organize. And that right has to be without, or has to have freedom from interference from employers. And then ang isa pa is free collective bargaining. So this is very important because collective bargaining is the process by which employers and unions negotiate the terms of employment, or that's what we call as labor standards. So kung natapos mo na yung Labor Law 1, which is labor law standards, those are, again, just a review, those are the minimum terms where the employer must comply and in which employees are entitled to. So those minimum terms, hindi siya set in stone. That's why those, for example, yung minimum wage, for example, yung bayad sa overtime, for example, yung number of sick leaves, for example. So those are fluid, and they can be subject to negotiations. So that's why we have so-called collective bargaining. So that is the policy, and that must be negotiated apart or free from coercion. So define concerted, nakalala natin kanina, that's a very prominent word in the definition. Concerted means a collective activity or organized activity executed collaboratively by individuals working together, and it may involve two or more people, or it could be a single individual acting on behalf of a larger group. So the keyword here is executed collaboratively by individuals working together. So that's concerted. Collaboration. So once there's collaboration of individuals, there's a concert. Tandaan na natin, so like Taylor Swift, when there's a concert, it's not a work of one person, pero it's a work of individuals working together. So ano yung purpose ng strike? Purpose of strike is to compel the employer to talk to the union in case of a deadlock. So pag may strike lang, pag may deadlock, in fact that's one of the grounds, no? And that's one of the most effective weapon of labor in protecting the rights of employees to improve the terms and conditions of their employment. As we have said, there's labor standards, and for example, there's inflation, there's a lot of factors going on. So the strikers or employees or union would like to raise those standards, and if hindi siya hindi siya ma-improve and they have a justifiable reason for it, then strike can be resorted to. So what are the characteristics of a strike? First, so there's an acronym here, EPTC. First, there must be an employer-employee relationship, and that the refusal of work is a means of persuading with the working men's demands. And number 3, there is a temporary work stoppage. And number 4, the stoppage is done through concerted action of the employee. So we can see here the relationship, and then the refusal or the means of persuading, and the time. Okay, so there's relationship, there's goal, there's time, and there's a manner. So kinds of strike. So there are different kinds of strike as to different categories. As to extent, there's general strike. Ito yung mga strike na it affects all employers, including those na walang labor dispute. And then second is local or particular. So sa general strike, that could include sympathetic strike, na kung wala naman sigurong labor dispute, may yung employees niya ay nag-sympathize. So that's another kind, no? So local or particular is only towards a specific employer. As to the nature of the act, strike, proper or primary or original or initial strike are declared by the employees who have direct and immediate interest in the subject of the dispute. We have sit-down strike. Workers stop working without leaving their place of work. Partial or quickie strike, unannounced short stoppage of work. And slow-down strike, a willful reduction in the rate of work by a group of employees for the purpose of restricting the output of the employer. So slow-down strike is yung parang nagdi-delay-delayan kayo, no? Unproductive kayo to show or for the purpose of compelling something to the employers. As to purpose, economic strike, this is very familiar, tanda natin to, because it is to force wage and other concessions from the employer and other terms and conditions of employment. So that could include to secure higher wages, to increase the minimum wage, higher overtime rate, compensation, and other economic benefits. So that's economic strike, and that's one of the grounds for strike, right? One of the valid grounds, which we will also discuss later. ULP strike is one that calls against the ULPs of the employer for the purpose of making him desist from further committing such practices. So unfair labor practice strike or ULP strike is one that calls out the employer to stop, to refrain, to enjoin from committing such unfair labor practice. So in summary, what is ULP? ULP is something or activities that are going against the right of employees to unionize. So we have degree of employee interest. There's primary, secondary, sympathetic. No? These are strikes staged by the workers of one company without labor dispute against their employers, but their purpose is to sympathize with the demands and grievances of another set of employees against their own employer. In other words, this is illegal because, again, the definition of strike is it must arise. One of its cause is it must arise from a legal dispute with the employer. Okay, so therefore it is illegal. Others, whipsaw strike is a strike by a trade union against only one or few employers in an industry or a multi-employer association at a time. So whipsaw, so parang I think we got the word lagare dyan. So one union only, so they are striking against one or few employers in an industry. What are the protections entitled to strikes? So first, against injunction or restraining order, because it is a right, but there's an exception to that later on. Employees not to be discriminated against merely because they exercise their right to strike. Number 3, the use of strike breakers is prohibited. Number 4, participation in a strike does not sever the employment relationship. So mere participation there in a legal strike, no? So, and then number 5, no arrest or detention may be made for union activities without previous consultations with the Secretary of Labor and Employment, except on national security cases or when crimes are being committed. So what is the status of a striking employee? Mere participation of a worker in a lawful strike shall not constitute sufficient ground for termination of his employment even if replacement had been hired by the employer during such lawful strike. So again, mere participation sa pagsa-strike, hindi siya dapat maging ground na paalisin ka or i-terminate ka. And then, another status is it must be temporary. And then the status remains, but the effect of such status as a laborer are suspended, such as wages. So, hindi ka makakademand ng wages pag nag-strike ka, of course. What should public officials do or not do? So, we have an acronym here, ROP. So, public officials would include the policemen. So, anong bawal gamitin ng mga police? So, they should not bring individuals to replace strikers in entering the strike area. So, they could be spies, no? Or they can be like to balloon, or maybe for other purposes. And number 3, or replacement for work in place of strikers. So, hindi pwede yung government mag-send out ng mga replacement, no? Number 3, they should keep out of the picket lines unless actual violence or criminal acts happen. Number 4, they should maintain peace and order and enforce the law and legal order. So, that's the only act or prohibited or allowable acts of public officers and the policemen. What is a picket? A picket are persons standing and going back and forth outside the place of work, protesting something or trying to persuade others not to enter during a strike. It is the presence of strikers who pace back and forth before the place of business of an employer considered unfair to labor in the hope of being able to persuade other workers not to work in the establishment and customers not to do business there. So picket, one of the keywords there is going back and forth. Ano yung purpose nila? Para yung iba sumali sa kanila, or yung mga customers or yung mga patients if it's a hospital or any other persons of interest won't interact with the business. Picketing may be done without a strike because workers may picket without engaging in work stoppage. So this is the unique thing with picket. Hindi lahat ng picket ay strike. Because pwede kayong mag-picket, pwede kayong mag-go back and forth, but hindi nyo sinastop yung inyong work. So how can that be? Well, we don't know. No? Maybe they're leaving their station for a while and going back and forth. So it is a form of freedom of speech if done peacefully, therefore it cannot be curtailed. So what are the factors affecting the legality of strike? Number 1, or they are actually 6, no? So number 1, if it violates a specific prohibition of law or substantive law. And then also procedural or remedial if it violates the procedural requirements. Number 3, if it has no valid purpose. Number 4, if it employs unlawful means. Number 5, if it violates an existing injunction. And number 6, contrary to an existing agreement such as the no strike clause or conclusive arbitration clause. So napaka-familiar yung last 2, that is very prominent din sa mga cases na injunction by the Secretary of Labor, for example. So let's go to them one by one. So specific prohibition of the law against strikes. So the right to strike, again, is not an absolute right. Okay, that's the premise. Di lahat, no? There are certain grounds where the law prohibits. So number 1 dyan, yung government employees. Do government employees have the right to organize and strike? May government employees validly form a union? So the complete answer here is not yes or no, but you have to qualify. Yes, government employees or those that work for government-owned and controlled corporations with original charter, wrong spelling ako dyan, have the right to self-organize for purposes other than strike. So that's the answer. Pwede kayong mag-organize, pwede kayong bumuo ng organisasyon, asosasyon, kung nasa isa kang kung nag-work ka sa GOCC, you can form any organization as long as you want. It could be co-op probably, pwedeng union, but the purpose must not be for strike. Strike's purposes also includes making demands. So yung strike hindi lang yung pagwewelga or pagpipiket, but that includes demands to bargain for better terms and conditions of employment. Bakit kaya? Bakit kaya bawal sa mga government or GOCC employees? Because of course that is they are they are impressed with public interest, and another reason is that they are under the civil service law. They are covered by the civil service law and should utilize such law to resolve their grievances. So pag may grievances sila, yung mga GOCC employees, they don't go striking. They go to the law and they go to how or what the law says about resolving their disputes. What are other prohibited activities in the conduct of strike? So ano yung mga bawal? O tingnan natin. Strike without having first bargaining collectively in accordance with Title 7 of the Labor Code. So bargaining collectively, that's a prerequisite. That could include resorting to pacific means or mga tinatawag nating amicable settlement. So grievance procedure, pwede rin dyan. That is also, that could include the stipulations under the CBA. So that's why it's very important to go back to the CBA kung ano yung sinasabi first before striking. Because without that, that could be a ground to invalidate the strike. So again, this could be considered or categorized as exhaustion of administrative remedies. Striking without first filing the required notice of strike. So that is a mandatory requirement. That's procedural. Number 5, holding a strike after assumption or certification of the President or the Secretary of Labor. So when it is assumed, or when they assume over the labor dispute, bawal na bawal mag-strike. Strike during the pendency of arbitration or cases determining the validity of the grounds for the strike or lockout. Again, what is this? This is, I think this is a little bit of advance. To determine the validity of the strike or lockout, that could be the cooling period, but that's subject for mediation at the 7-day strike ban. So, sa tatlong grounds, mamaya nasasabihin natin for strike, there is a required period wherein the validity of the strike or the strike vote is determined. Okay, so bawal mag-strike. If mag-strike dyan, that is illegal. Violated, number 7, violated the no strike provision of the CBA and during preventive mediation. Sorry. So, violation of a no strike clause, that's a ground for an illegal strike. So, question, is a newly certified union or new bargaining agent bound by the no strike stipulation between a deposed union and the employer on the ground of the substitutionary doctrine? So, this is a case-based question. So, merong union na depose siya or na-defeat siya in the certification election, and may bagong union na nag-represent as the SEBA or the sole exclusive bargaining agent. So, may CBA yung natalong union, and there's a stipulation there that bawal na bawal silang mag-strike. So, ang new union nag-strike against the employer. So, in-invoke ngayon ng employer na uy, meron tayong CBA. So question, bound ba yung bagong union to observe the no strike clause under the old CBA? The answer is no. Because if you use the substitutionary doctrine, this cannot be invoked. Only because a substitutionary doctrine only provides that employees cannot revoke the validly executed CBA with their employer just by simply changing their bargaining agent or just by the certification election. The new agent must respect the CBA and cannot renege on their obligations, except of course to negotiate with the management for the shortening of the CBA. So hindi pwede under the substitutionary doctrine yung mga employees hindi nila basta-basta i-revoke yung CBA just by electing a new SEBA, okay, a new bargaining agent. Hindi yan pwede, because that will violate the primacy of contracts. So ano yung reason? But this doctrine cannot be invoked to support the contention that a new CBA automatically assumes all personal undertakings like the no strike stipulation in the CBA of the deposed union. Yes, hindi ma-revoke ng new election yung previous CBA, but hindi naman siya ini-impose lahat ng undertakings sa old CBA, hindi siya ma-impose sa new SEBA or exclusive bargaining agent. When the deposed union bound itself and its officers, it could have not bound other rival unions. It was the agent of the employees, not of the other unions, which have distinct personalities. So this is in the case of Benguet Consolidated versus BCI employees. Also, if the newly certified union does not formally adopt the existing contract as its own, it cannot be bound. So answer is, yes, substitutionary doctrine says that hindi pwedeng ma-revoke yung existing CBA, pero yung mga personal obligations or undertakings like the no strike clause ay hindi rin pwedeng ma-impose sa newly certified bargaining agent, especially if that new certified agent did not formally adopt the existing contract. So are acts calculated to force disruption of operations and thereby violating the no strike clause of the CBA, illegal strike? In other words, may mga acts, kunwari yung union gumawa sila ng actions na nag-disrupt ng operations, na nag-lead siya sa pagsa-strike na illegal. Yes, deliberate and concerted actions determine the authority of the company to undermine the authority of the company are not protected actions. Actions that suggest that something is amiss and that there is something out of the ordinary is afoot. The hotel does not, or the company does not need to advertise its labor problems with its clients. The union succeeded in forcing the hotel to choose whether to allow them or refuse them to work, even if it had to cease its operation. The act of the union was not merely an expression of their grievance, but a calculated act to inflict serious damage to the hotel's finances or its reputation. Thus, this is unprotected and should be considered an illegal strike. Dusit Hotel versus CA. So sa case na ito, meron silang stipulation sa kanilang CBA na bawal mag-strike. Kaya lang, hindi naman sila explicitly, automatically nag-strike kaagad, but what they did is nagpakalbo sila, which led sa pagbabawal sa kanila ng mga guards. So syempre employee sila. Sa hotel, first class hotel yata to, nagpakalbo sila, so syempre hindi sila pinapasok. So anong ginawa ng company? Dahil walang naubusan sila ng trabahador, they suffered the brunt of it. The company was forced to stop their operations. And then since hindi naman sila pinapasok, nag-strike sila. So sila yung kumbaga nag-react din sa kanilang sarili, yung mga employees din mismo yung nag-strike sa kanilang sarili mismong kagagawan, no? And the court said na that is an illegal strike. Therefore, yung mga union officers na nag-compel sa strike na yun na magpakalbo kayo, they can be automatically terminated. So let's go to the last section of this video, which is procedural requirements of a strike. So kanina substantive. Now, so the very first area of procedural requirements is exhaustion of all pacific remedies and grievance procedure. So dapat wala mo ng strike kasi that is frowned upon. That can militate against economic activities of our country. So dapat pacific muna, dapat peaceful muna. So that could include conciliation, mediation, and compromise. So dapat ma-resort muna yan. And that could be those laid down under the grievance procedure in the collective bargaining agreement. And if hindi siya mag-work, dapat, next question is, meron bang valid ground or strikeable ground na pwede kayong mag-strike? In other words, is there a labor dispute? So meron lang tatlong grounds for a strike. First is bargaining deadlock, and that is more specifically deadlock as to the economic provisions of the CBA. So again, tinatry erase, for example, ng union yung labor standards, yung minimum wage, but the employer says, I won't. So nagkakaroon ng deadlock or yung impasse. Letter B is ULP or unfair labor practice, which could be subject of another video. In other words, the summary of this is rights or actions that violate the rights of employees to organize, okay, or to unionize. And letter C is union busting. These are actions that threaten the existence of a union. So next would be notice of strike. Third is cooling off period. And summarize ko lang ha. Next is striking vote or strike vote. Number 5, strike vote report. Number 6, strike ban. Okay, strike ban. And the last would be the staging of strike. So isa-isahin muna natin. Exhaustion of pacific remedies. What are the pacific means to resolve a labor dispute? And what happens if a strike is resorted to while having these specific measures? So of course, that would be illegal. Conciliation, mediation, and compromise, these are the top 3 pacific means. So dapat peaceful muna tayo. So habang nagkakaroon ng mediation or compromise at nag-strike kayo, that means a sabotage, no? Tinatawag ng court ito as a sabotage for a peaceful conciliatory process. When is mediation mandatory? It is mandatory when upon filing of a union of a notice to strike, the NCMB declares the notice of strike as appropriate for preventive mediation. So ito yung sa case ng PAL versus Secretary of Labor. Nung nag-file yung PAL employees na they would strike, the NCMB declared that this is appropriate for preventive mediation because of course it is an industry impressed with public interest. What is the consequence of failure to exhaust all pacific remedies? Instead of exhausting all the steps in the grievance machinery provided under the CBA to resolve the dispute amicably, the UFE went on strike, hence the strike was illegal. So this is under the UFE versus Nestle case. So again, this is an illegal strike. So dapat i-exhaust muna lahat, especially the mediation provisions. So now, valid grounds. Who can be or when can a violation of a CBA be considered ULP? So lahat ba ng violation sa CBA, pwede na kayong mag-strike under the by reason of unfair labor practice? No. It must be flagrant and malicious refusal to comply with its economic provisions. What are grounds where can a strike not be declared? So, ito yung mga unvalid or invalid grounds, kumbaga. So, inter-union or intra-union disputes. Why? Because this is resolved with the Bureau of Labor Relations, which is a part of an earlier topic under the Labor Relations Code. Then, without filing a notice of strike or lockout, then without the necessary strike or lockout vote obtained and reported to the NCMB, when the Secretary of Labor has assumed jurisdiction. So of course, that is a national interest case. And then there is a certification that the dispute be submitted to compulsory or voluntary arbitration, usually by the NCMB. There is a pending case involving the grounds of strike or lockout, and that's it. Notice of strike, the second step. Notice of strike, where to file. This is filed before the DOLE regional branch of the NCMB or the board. There must be a copy furnished by the employer or the union. So, mag-submit kayo ng file notice of strike saan? Sa DOLE, sa NCMB. NCMB is the branch of DOLE that has the obligation to accept these notices. Who files a notice of strike? So, we have to categorize the answer. It means who can strike. So syempre, strike, it can only be done by employees. So only a legitimate labor organization can hold a strike. And just to review, paano maging isang legitimate labor organization? Of course, that must be certified. No? One of the elements is certified by the department. If the grounds is ULP by the employer, who can file? So unfair labor practices by employer. Who can file? The duly recognized agent or the certified bargaining agent of the collective bargaining unit. The bargaining union only. Ito naman, sorry sa but the bargaining union only pag meron tayong union busting, no? Next, what can be done instead of filing a notice of strike? So may alternative pa rin ba? Yes, and then pa rin yung pacific means. Request the NCMB to do preventive mediation. Meron isang case na nung nag-file sila ng notice of strike, nagkaroon ng request for NCMB kasi hindi pa nagkaroon, maybe wala sa CBA. Okay? or alternative dispute resolution, which is a preferred mode. No? When is a notice of strike considered dismissed or invalid, or when no strike should be declared? During the running of an existing CBA and outside the freedom period, when there is no strike provision under the CBA, when the NCMB declares the notice of strike as appropriate for preventive mediation. This is under PAL versus Secretary of Labor. So, nung sa case kasi nito, there is a yung nag-declare na yung NCMB na appropriate siya for preventive mediation pero nag-strike pa rin sila. Therefore, the strike was invalid. What is the effect when NCMB declares a notice of strike as appropriate for preventive mediation? Again, the union must drop the case because that is under the NCMB rules. Okay? When the secretary delays in acting promptly, is it an excuse for the union to declare a strike? The answer is no. It is not an excuse for a union to declare an illegal strike and escape primary and exclusive liability, PAL versus Secretary of Labor. What if the notice of strike is premature? The answer is the employer may move to dismiss the notice of strike. So let's go now to the cooling off period. So after kayo nag-notice, nag-file ng notice sa DOLE, magkaroon dapat ng cooling off period. Ano yung purpose nito? From the word itself, to cool off the minds, to cool off tempers. The NCMB mediates and conciliates the parties to encourage the parties to submit to voluntary arbitration. So kanina, yung exhaustion of Pacific means, now, may cooling off period pa rin. So hindi siya titigil, no? Hindi tayo titigilan na magkaroon ng friendship uli or magkaroon ng Pacific means, peaceful means. Kung pwede pa lang, iwasan nating magkaroon ng strike. Then, what grounds does not need cooling off period? Meron namang grounds, isa lang. Sa tatlong grounds, di ba kanina, may tatlong grounds, isa lang yung walang cooling period, and that is union busting. Okay? What is union busting? Just a review. Actions undertaken by employers to dismantle unions or prevent employees from joining a union. In other words, this is a threat to the life of the union itself. Ano yung elements? Officers are being dismissed. Those officers are the ones duly elected in accordance with the union constitution and bylaws, and the existence of the union is being threatened. What are the cooling off periods for various types of strikes? So for bargaining deadlock, the cooling off period is 30 days. For unfair labor practice, 15 days, and 0 days for union busting and no notice of strike. But tandaan natin, sa union busting, mandatory pa rin yung 7-day strike ban, which we will discuss later. What should be done by the parties during the cooling off period? They should not do any act or refrain from any act that would disrupt the early settlement of the dispute. So, di ba pinapabate na kayo ng NCMB? Wala dapat gagawa ng aksyon na magdi-disrupt nito. At dapat mag-participate sila sa lahat ng meetings na gagawin ng board. Next, how shall information be treated during the cooling off period? Ano yung mga information na, siyempre nagbabangayan siguro kayo dyan, nagbabargaining, nag-uusap-usap. Yung information na mabibitawan at naririnig dyan ay privileged communication. In other words, hindi siya magagamit as witness or statements sa korte or as statements under bad faith. When does the cooling off period not apply? Again, that is when there is union busting. Let's go now to the fourth step, strike vote. What should be done before a strike vote? Give notice to the NCMB at least 24 hours before the strike vote meeting. Why notify? So, why notify the NCMB? Bakit kailangan i-notify yung before the strike vote? Para ma-determine nila kung sasali sila sa meeting to determine na fair or may representation. Okay? How is the strike vote done? Okay, ano yung primary element? That is must be secret balloting. Siyempre, kasi pag hindi yan secret, malalaman ng someone there kung sino yung gustong mag-strike, and that could be subject for, mainitan siya. Mapag-iinitan siya ng someone also. So, that there must be a meeting called for a purpose. What is the needed vote? So that's 50% majority, 50% plus 1 of the total union membership. So kung sino yung magsa-strike, dapat majority sa inyo gustong mag-strike. Next, can dismissed but contested union members be included in the majority? The answer is yes. Kasi pag hindi mo sila ginoin, tinatawag yung undue, hindi tayo nag-observe sa due process. Parang kahit ano sila, nagko-contest sila sa kanilang dismissal, tinituring mo silang already dismissed. So, walang due process. So, dapat they must still be included in the majority. So, this is in the case of Industrial Timber Corp versus NLRC. So, we go now to the fifth step, strike vote report. When should a strike vote be reported? It must be reported at least 7 days before the intended strike or lockout. So, again, this is really mandatory, yung 7 days na to. This is mandatory because dito yung nire-report na mayroong ginawang strike at gustong mag-strike ng mga union members. Ano yung purpose? Again, ano yung purpose ng 7-day strike ban? To determine or verify that the projected strike carries the imprimatur of the majority of the union members. So, demokrasya pa rin. So, yung pagsa-strike dapat gusto ng lahat or ng majority. And to determine na walang coercion or walang sapilitang nangyari dyan, walang dinaya dyan. Okay? Fair yung pag-conduct ng election. So, is this part of the cooling off period? No. The 7 days is not a part. Hindi siya part ng 30, 15, or 0. So, ito yung formula dyan. No? Again, pag 30 pag deadlock, 15 pag ULP, 0 pag union busting. Strike held within the 7-day ban, anong nangyayari? That's an illegal strike. At pwedeng tanggalin yung mga nag-participate na officers at yung mga gumawa ng illegal acts na members. So, strike ban, dito na tayo. This is mandatory. How many days? 7. So, what is strike ban? It is the 7-day period after the strike vote is reported to the NCMB where the union is prohibited from staging a strike. So, kailan magko-commence yung 7-day strike ban? The moment it is reported to the National Conciliation and Mediation Board. Is it mandatory? Again, emphasized, yes, even in the case of union busting. Is the 7-day ban still applicable if union busting has been voted and its existence has been proven? Yes. Again, inulit ko lang, it is still mandatory. What is prohibited during the pendency of the preventive mediation proceedings? So ito yung parang sa ano na to, sa unang na kanina to, no? Wala dapat mag-strike kasi pacific means. So hindi ito under sa strike ban, sorry. But again, pag merong mediation, conciliation, alternative dispute resolution, walang magsa-strike. Okay? What is the effect of declaring a strike within the period of determination of the Secretary of Labor and Employment whether or not to assume jurisdiction? So, in national interest cases, pag ang isang company, for example, ay under sa isang national interest, hospital, for example, or that is a big company like Nestle, and then nag-assume or nag-file ang employer, for example, in the case of Nestle, nag-file siya, nag-petition siya sa Secretary of Labor, please assume this labor dispute. So, yung Secretary of Labor, dinidetermine niya pa kung, I think in that case, no, dinidetermine niya pa kung kailangan niyang mag-assume. But while he's in the determining stage, nag-strike yung union. So, that is, the strike is illegal. PAL versus Secretary of Labor. Ay, hindi pala yun. Sa PAL versus Secretary of Labor. So, are the cooling off periods and 7-day strike ban mandatory? So, inulit ko lang. Yes. That is also held in UFE versus Nestle. Okay. What if some of these requisites above are not met? So, what if yung 6 na yun, na procedural requirements, hindi na meet? Again, illegal. Illegal strike. What is the effect of an illegal strike? So, anong epekto nito? We have to divide to two. Now, as to union officers, disciplinary actions may be done against them for those who took part in it. So, pag union officer ka, umattend ka lang, pwede ka nang madisiplina. Okay? Umattend ka lang ng illegal strike, disiplina ka na kaagad. But if you're a union member, pag umattend ka, it will not be taken against you only if you committed illegal acts during the illegal strike. Article 279. So, question, what are the illegal acts during the strike? Acts of violence, coercion or intimidation, or VCI, obstruction of ingress or egress from employer's premises, and number 3, obstruction of public thoroughfares. So, pag hindi nyo pinapasok, yung mga other employees na hindi nag-strike, pag nanunto kayo dyan, pag gumawa kayo ng bad words kayo, that could be a form of intimidation. So, those are illegal acts. And if you did that as a member, you can be terminated under Article 279E of the Labor Code. So, ito, ulit siya. When is a mass demonstration not considered a strike? May isang case na nag-participate lang yung mga employees, no? I think they protested against the police, no, sa kanilang ginawang So dito, when the company learned that its employees are planning to protest against the alleged abuses of the police, the company, the Philippine Blooming Mills, called a meeting and warned the union officers not to participate in that demonstration or not to conduct that demonstration. Sinabi naman ng union na ang demonstration had nothing to do with a labor dispute with the company. But then, the workers proceeded with the demonstration at yung company nag-file ng ULP case against the union for the violation of the no-strike clause of the CBA. So, CIR declared that the union officers are guilty of bargaining in bad faith and violation of CBA. But it was appealed to the Supreme Court. Ang question is the union guilty of unfair labor practice and violation of the contract bargaining agreement? The court said no. The mass demonstration was not a strike. That was against the abuses or alleged abuses of the police. That's why they demonstrated in front of Malacanang. And that it was there was indeed a temporary stoppage of work, but according to the court, it must be tested against the principles of democratic society. Okay, it was an exercise purely of the freedom of expression and the right to assembly and petition for redress of grievances before the government or before the president, policemen, and the local government of Pasig City. In fact, sabi ng court, in fact, duty pa nga ng company to protect the union from harassment of the police officers. The interpretation of the commissioner of the CIR that the CBA clause was violated cannot be used to deny the workers of their higher right, which is the constitutional right to stage a mass demonstration against the police abuses during working hours. Otherwise, this will be a tyranny over the mind of the workers. This freedom to assembly must not be curtailed by a mere slender ground of invoking the CBA clause against non-strike, no strike. So, that is the case of Philippine Blooming Mills employees versus Philippine Blooming Mills. This is the end of part 1 of the Law on Labor Strikes. Thank you very much for watching. God bless. Have a great day.